Now, the Western Cape High Court has dismissed the public protector's bid to halt the parliamentary process that could see her impeached. For reaction on this, I'm joined by Paul Hoffman, the Director of Accountability Now. Mr. Hoffman, thank you for your time this afternoon. In effect, what does this mean for the public protector?
Yes, well, in effect, it means that the public protector is now going to have to face the music. And this is music where we struck up the orchestra as long ago as January 2017, when she was barely 4 months in office. We wrote to the oversight body in Parliament, the Justice Committee, and said, look out, this new public protector doesn't seem to know how to run her office and doesn't seem to be dealing with us honestly as she should. She had pretended to us that there was no interim report in relation to the CIEX complaint, which is at the root of the parliamentary process against her, when in fact there was such a report. And we caught her in a lie. But the parliamentary committee did not do anything about it. And it was only after the Constitutional Court found that she had misled it in relation to the Reserve Bank's complaints about her handling of the CIEX report, that her competence and her honesty came into question in Parliament. The problem that Parliament has is that it has no rules in relation to what needs to be done if a leader of a Chapter 9 institution paints outside the lines or behaves badly. That's not fatal. She's only entitled to have the rules of natural justice observed in any proceedings against her. And the process that Parliament has gone through in setting up this 17-stage set of rules for disciplining leadership of Chapter 9 institutions is really the codification of the fairness requirement of natural justice. So she is going to now have to face an inquiry in which she is entitled to be treated fairly. If she is not treated fairly in that process, then she can come back to court and say, I have been given a bad time. But the court has said there's no irreparable harm to her. And that's entirely distinguishable from the situation in which Minister Gordhan found himself. I hear her spokesman relying on the irreparable harm aspect of the law when you are seeking to get an interim interdict. Well, applicant in this case is actually the public protector herself, as was the case with Pravin Gordhan, where he was the applicant. It's not necessary that the respondent have some irreparable harm. The irreparable harm has to be to the applicant. And clearly, the attempt to interdict the hearing pending a determination of the validity of the rules, that is, their legality and constitutionality, is not going to help in the context of being given a fair hearing by the parliamentary processes.
I mean, this only means that Parliament can now start their inquiry. It's just really the beginning of a process which could take a long time. And should their findings be adverse against the public protector, surely she is in a position to appeal those. And should she appeal, could that not then move the ball and roll the ball further down the timeline to perhaps even the end of her term? And would all of this have even mattered?
You've hit the nail on the head, Thami. I see you've done your homework on this one. The game that the public protector is playing is to spread out, to prolong the process, to avoid the hearing in order to get to the end of her term of office. She started in October 2016. She had a doable term of office of 7 years, and if she plays the Stalingrad strategy, shall we say, with skill, she will get very close to the end of her term before the process is allowed to unfold.
Well, the other case scenario is that indeed this process does have its natural end. In the instance, let's say she is found to not be fit to hold office, what are the implications then for the findings that she has made up until that particular ruling is made?
Her findings are regarded as valid, and the only way that they can be set aside is that if a person or a Department of State that is the butt of findings made goes to court and takes the findings on review, as happened when Minister Gordon reviewed the disciplinary proceedings that she said he should be subjected to by the President. So in other matters in which there is no review pending or brought timelessly, the findings of the Public Protector's Office will stand in spite of the fact that she is found unfit for office.
And should she perhaps be venerated from all of this? Does she have any sort of retributive action that she can take against those who have put her through so much emotional and psychological trauma?
I think she's brought the emotional and psychological trauma on herself. You know, I asked her to explain in January 2017, I asked her to explain herself, and she said, I do not investigate myself. When I went back to her and said, but I'm not asking you to investigate yourself. I'm asking you to account for telling me that there is no interim report in the CIX matter when in fact there is one. And she said, take me to Parliament. And she was taken to Parliament, and Parliament did nothing about it. She was protected by the chairman of the then chairman of the Justice Portfolio Committee. Nothing came about. No correspondence with Parliament was ever answered. No representations to members of the committee had any effect.
All right, well, Mr. Hoffman, we'll leave it at that for now. Thank you for your time this afternoon. That's a Director of Accountability now, Mr. Paul Hoffman, and that ruling coming out. So the inquiry into the suitability of the Public Protector to hold office will now begin in Parliament.